afternoon, our viewers at home. Welcome again to another episode of Insights from Ex-Matters Legal. My name is Akinleye-Martins, your host. This week, we'll be discussing a different angle to our commercial law discourse in terms of international arbitration, which we have discussed a couple of episodes back. We've discussed certain issues on international arbitration, but today we want to look into the interim reliefs available to parties in an international arbitration. So when we say interim reliefs, what do we mean? It's actually very critical in any form of dispute resolution, be it litigation or arbitration. And at times, parties may need to approach the court or to approach the arbitral tribunal to seek for certain reliefs pending the outcome of the matter in court, if it's a litigation, or the arbitral process in the case of an arbitration. So in an international commercial arbitration, generally, most of the time, arbitration internationally or locally will deal with commercial disputes. So parties may need to seek interim measures, interim reliefs, like injunctions and attachments, where they feel that the res, which is the subject matter of the dispute, may be in danger if certain measures are not taken to protect that subject matter of the dispute pending the time the matter is resolved either in court or in the arbitral tribunal. So, as it is really, the interim reliefs and interim measures, the process for getting interim reliefs or interim measures is literally the same, both in arbitration and in civil cases, in litigation matters. And this is where the courts are very relevant when it comes to arbitration. We have discussed in our previous episodes about the involvement of the courts in international arbitration, whether we can localize or take away the involvement of the courts when it comes to the place of arbitration. So we see that in the issue of requesting for interim reliefs, parties to an arbitration would have to seek this redress from the courts, the national courts of the place of arbitration. So, in a sense, you cannot really practically delocalize, the arbitration from the involvement of the courts in the place of arbitration, which in law, in the Latin maxim in law, we refer to as the lex arbitri, which is the place of arbitration. So what are interim reliefs as it were? What are the injunctions, that could be requested for? And what are the conditions, that the court will look at before granting those reliefs to the parties requesting? So the parties to an arbitration seeking redress in court saying, yes, we are in arbitration, however, I need the court to give an order of an interim injunction or an interlocutory injunction to say, please, let this subject matter be protected so that the other party or the adversary, as the case may be, will not tamper with the subject matter of the dispute pending the outcome of the tribunal arbitration process. So, what are interim injunctions? We have certain injunctions we call interim injunctions, which basically deals with a party going to the court seeking temporary relief, for a certain period. So you seek an interim injunction even in civil procedure, in litigation matter. You seek an interim injunction, making an application, seeking a temporary order of the court to restrain the other person from doing an act or a series of acts, pending the outcome of a particular process in court, and in case of arbitration, pending the outcome of the arbitral tribunal's decision. Albeit in an interim injunction, it can be secured ex parte because you are seeking for a temporary order. When we say secured ex parte, it means the party who is seeking that redress, that interim relief, does not give notice to the other party to the dispute. Ideally, under the court process, both parties have to be informed if an application is filed in court. But there are times an application could be filed in court and the other party is not put on notice, probably because of the urgency and the emergency involved. So they can bring the motion ex parte, which means you bring the motion without notice. Only one side brings the motion without notice to the other party. And so the injunction, the interim injunction, could be issued by the court for a certain period. Most of the time they issue interim injunctions. The court will issue interim injunctions in practice most of the time for a period of 7 days or maximum a period of 14 days, within which the party who sought that redress in court, that relief in court, will have to ensure that it gives the other party notice that, yes, I've gotten an interim injunction, maybe to make sure that this subject matter is not tampered with. However, there will be a period of time, maybe 7 or 14 days, that interim injunction will have to lapse. And within that period, the other party has to be put on notice that, yes, there is an injunction, to make sure that this rest is not tampered with, pending the outcome of the decision. In the case of arbitration, pending the outcome of the decision of the arbitral process. And there's also a second injunction that could be obtained apart from interim, which we call the interlocutory injunction. So a party to an arbitration could go to court and seek for an interlocutory injunction through a motion on notice, putting the other party on notice. So the difference between the interim and interlocutory injunction is basically in whether you're putting the other party on notice or not. So if you are seeking that injunction ex parte, that will be interim injunction that will be, will be granted. However, if you are putting the other party on notice, pending the time the suit is properly determined in the case of litigation, but as we are discussing in the case of an arbitration, pending the time the arbitration process is concluded and a decision is given, then the party could seek interim. That's why it's like an interim release, just for the period. That's why, in the word interim, it's just for that period to make sure that the rest of the subject matter is protected. So the interlocutory injunction will be applied through a motion on notice to the court, to the national court of the place of place of arbitration, which is the seat of arbitration. And if the order is granted, it will last pending the determination of the arbitral process. So basically, there are certain conditions, that will have to be fulfilled, before a party seeking this interim relief, maybe via an interlocutory injunction, would be granted that order. So if the court does not see those conditions met, the court will not just grant this order. So any party going into an arbitration, seeking an interim relief before the national courts of the place of arbitration should ensure that these conditions are properly met. There are instances where a party to arbitration, will have to seek these reliefs, pending the determination of the arbitral proceedings. So the applicant has to fulfill certain conditions. One of the first conditions that has to be fulfilled before the court will grant an interlocutory injunction, is there an existence of a legal right by the party even seeking this injunction? So, is there a right legally to be protected? If the court does not see that the party has a legal right, even in the matter involved, then the court will not grant that interlocutory injunction. So the party to the arbitral process must ensure that, yes, there's a legal right, to be protected. And there's a legal right in existence. So you cannot come and bring how do I put it? You cannot come and bring a matter in a case where you really don't have a cause. You are not privy to it, and you say, okay, yeah, you want the court to grant you an injunction it's not going to work that way. So there has to be an existence of a legal right. So as a general rule, party to proceedings will have to apply for this interlocutory injunction, and if it's granted in favor of that party, if there is no counterclaim, then that injunction will subsist pending the determination of that arbitral proceeding. Secondly, is there a substantial issue to be tried, whether before the arbitral tribunal or before a court? So that condition has to be fulfilled. If the court does not see that there is a substantial issue to be tried, they will not even grant any injunction to protect the subject matter. So the court has to be satisfied that there is a substantial issue to be tried in that particular case, that the suit is not a frivolous one, or the dispute before the arbitral process is not frivolous and is definitely going somewhere, because the court will not want to waste its time. So that's very, very important for the parties to an arbitration process to understand. Then thirdly, what's the balance of convenience? Balance of convenience in the sense that it's a factor that has to be looked into, because you have to ensure that you satisfy the court that the balance of convenience is in favor of the party seeking that injunction. That is very, very important. So the balance of convenience has to be in favor of that party seeking for the injunction, ensuring that, yes, if this injunction is granted, it will favor me to protect the rest, to make sure that the other party does not tamper with the subject matter of the dispute. So it's a question of who will stand to lose more or who will stand to gain more if the status quo is maintained, in the sense that if that injunction is granted. So who will lose more if the status quo is restored, or who will lose more if the status quo is maintained? That is very, very important, for the court to determine that the balance of convenience must be in favor of the party seeking that redress. The fourth condition or factor that the court will look into before granting the interim relief: is there an irreparable damage or an injury that will be caused to the party seeking the interlocutory application if this injunction is not granted? So, if to say, let's assume the arbitral tribunal process is going to take, for instance, give or take, let's say it's going to take like 4 months or 6 months. Within that period, is there going to be an irreparable damage or an injury to the party seeking injunction? If there would be, then that injunction could be granted to ensure that if the other party tampers with the subject matter or tampers with what is being requested, to be protected, there's going to be an irreparable damage to the party seeking that application. So, for example, if the arbitral process, in the arbitral process, 2 parties involved, the party seeking injunction, if he knows that the other party, which in litigation will be the defendant, if he knows that, yes, if the claimant knows that the defendant, if he tampers with this thing, it's going to be an issue. And if there's an issue, it's not something that can ever be repaired. Then that claimant or the other party to the arbitral process can go to the court and approach the court and say, grant this injunction against this party to make sure that that rest is not tampered with. So that has to be fundamentally determined by the court. Then the conduct of the parties. The court will look, because before granting injunction really is at the discretion of the court. And the court has to be satisfied that what are the conducts of the parties in this case. So if one of the parties are not conducting themselves properly, as it were, the party seeking relief, if he's not conducting himself properly, the court may not grant that interim relief. So the conduct of the parties is very, very important. Also, the party seeking relief must be able to give undertaking as to damages, in the sense that if at the end of the day it is discovered that the injunction was obtained in a frivolous manner to deceive the court, then damages will have to be paid to the other party against whom the injunction was sought. So he has to be able to give undertaking as to damages. So these issues are very, very important when a party is going to the National Court of the place of arbitration to seek injunction, to seek for interim reliefs, pending the determination of the arbitral process. Yes, in international commercial arbitration, the interim reliefs are major factors or fundamental elements that are available to the parties to the arbitral process to ensure that whatever is being disputed upon is not tampered with pending the determination of the case. So in international arbitration, there are various advantages, as we can see, while injunction is very, very important. However, these conditions that we've mentioned must be satisfied before the National Court of the place of arbitration grants this relief. And, to have a recap, there has to be an existence of a legal right. So there has to be a legal right being protected. The party seeking that injunction must have a legal right before it can go to the court. There has to be a substantial issue to be tried, not a frivolous matter before the court or before the arbitral tribunal. There has to be undertaking as to damages that the party seeking injunction will have to give that undertaking. That if this injunction is obtained in a deceitful manner, for instance, and it's discovered that, okay, the party that sought for the injunction misled or misrepresented facts, then it would have to pay damages to the party against whom the injunction is sought. There also has to be the issue of the fact, that the balance of convenience is in favor of the party seeking that injunction. Then is there going to be an irreparable damage or an injury to the party seeking the injunction in the event that the other party tampers with the subject matter of the dispute? So these interim reliefs, albeit very important, these conditions must be fulfilled, as the court must be satisfied as aware that these conditions have been met before these interim reliefs are granted. And like we have mentioned, interim reliefs could come as interlocutory injunctions or interim injunctions or attachments. When we say attachments now, that the court could give an order to attach the particular subject matter pending the determination of the arbitral proceedings. So this week, we've looked into something seemingly simple, however, is very, very germane and crucial when it comes to international arbitration, especially when it comes to the involvement of the national courts of the seat of arbitration, and what makes parties seek redress before the national courts during an arbitration. So, requesting for interim release are reasons why the parties to an arbitration would go to the national court of the seat of arbitration. And we've also seen that the conditions we've mentioned, the 5 conditions, must be met, and the court must be satisfied that these conditions or these factors, as it were, has been met and fulfilled before they could grant either the interim injunction or the interlocutory injunction, as the case may be. And it should also be noted that injunctions, interim reliefs, the redress being sought by the party to an arbitral process is at the discretion of the court to grant. So if the court is not satisfied enough, then the court may not grant that injunction. And that is why parties to an arbitration should ensure, that they get their matters, evidences, everything they want to bring before the court. They get it right when making the application to ensure that their application for the injunction is not thrown out, by the court. So thank you very much for listening to us this week. We believe you've been able to gain one or two things when it comes to what to do in approaching the court for interim reliefs during an international arbitral process. Till we come your way again in the next episode, say God bless and thank you.